All right. Hello, everyone. How is it going? This is immigration attorney Moumita. I'm coming to you live from New York City. I'm here to talk about immigration and talk to you about what may be on your minds. Thank you so much for joining me. I have a lot of my current clients, a lot of my friends and followers who are watching. And today I want to ask you a question. I want to know, are you afraid of filing for Vawa because you are afraid that it's going to affect your spouse? Have you been watching my videos from month after month, knowing that this is the case that is right for you, knowing that you need this relief, knowing that you're going through a lot of problems in your marriage to a US citizen. And despite that, even though whatever you're going through may be hurting you so much, you are still afraid to file for VAWA because you're afraid it's going to affect your spouse? Well, I'm going to dive right into that question, and then I'm going to take some immigration questions live from all of you. So let's talk about this. If you have been watching me or you have been looking into the VAWA application, which is a self-petition green card application for yourself, but you have been afraid to do so because you are afraid that doing this will hurt your spouse in some way, I'm here to let you know that if you decide to take this momentous step for yourself to help yourself get a green card and file for VAWA, it will not affect your American citizen spouse in any sort of way. Neither would it affect any green card holding spouse if your spouse is a green card holder, because this is simply the simple truth is that this is a humanitarian case that is meant to help you. And immigration is not in the business of trying to upset your family life or trying to hunt down your spouse and do something. This is a completely confidential, protected case. No one will ever know what you have said in it or said about what's happening in your life, except for your attorney and immigration. And as well, it will not be disclosed to your U.S. citizen spouse. It will not be made into a public record. It will not affect their record in any sort of way. And they will go ahead and live their lives the way that they want to. But you will instead be on a journey to secure your own status and to give yourself the immigration justice that you need. And I would be very, very happy to discuss this case because I know that these are valid concerns. You know, when you're in a relationship with somebody, no matter what is happening to you, you still care about them, you still love them, and you have had good times in the past, right? However, I want you to realize that, immigration status in this country is something that is not always that easy to get. So if you have this opportunity to do this, and when you've been told that it will not affect your spouse in any sort of way, I encourage you to find out more about it, to get your case evaluated, and to find out if it is the right thing for you to do, okay? If you would like to have an appointment with me to discuss your case for me to evaluate it, please give us a call at 212-248-7907. And I have a question here already about VAWA, which is from JS, who's asking, hi, Moumita, is VAWA only for immigrant spouse? What about the non-immigrant spouse whose AOS is impending and if primary applicant tries to withdraw or leave the country in the middle for some reason? From JS. So let's talk about this. VAWA is specifically meant to be a benefit for those who are spouses of either a green card holder, which is a permanent resident, or of an American citizen. If you are married to somebody who doesn't have a green card or who does not have citizenship and you're doing a green card process together and they're in control of it, they try to withdraw it or they try to cancel it, they leave. The bad news is that you may not be able to do anything regarding this. However, there is a special case called the I-765 VS, and it's for spouses of H-1B visa holders and also of L-1s, I believe, who have suffered domestic violence. And it's almost not really like VAWA, but it's the ability to get a work permit for yourself. And keep in mind this one thing also. If you have ever suffered physical violence by your spouse, no matter whether your spouse is a citizen or undocumented or whatever they are, you may be eligible to also apply for a U visa if you have ever reported the crimes committed against you and you have also cooperated with law enforcement in order to report that crime, okay? So yes, your options may be more limited if your spouse is not a US citizen or a green card holder, but you never know what you may have as an option, okay? And the second thing that I want to talk about today, that another very frequent common question that I get is, if you have gotten your 2-year residency card, but you and your spouse are no longer together, you've gotten divorced, do you have the option to file for the 10-year green card through the I-751 application to remove conditions, even though you're divorced? And the answer is yes, you can still apply by yourself. You don't always need to have your spouse join into this application with you. And in fact, the government allows several different waivers of the joint filing requirement for somebody who may be divorced from their U.S. citizen spouse, or who may have suffered extreme cruelty and battery during the marriage, before getting the 2-year green card, or even after getting the 2-year green card. And also, if you would suffer extreme hardship were you to not get approved for the 10-year card, you could also request a waiver of that as well. So the bottom line is that if you have a 2-year green card, and you may have probably struggled to keep it together until you got that green card, and now you're still struggling a bit in that marriage, and you're going through things, and your spouse either won't help you file, they won't go to the interview, or you have gotten divorced, you may still be able to continue the case by yourself. Taking immediate action is the number one thing that you can do for yourself, and I would be happy to take your call. Give us a call at 212-248-7907. Just to note that when you call us, you will be speaking to my team, my amazing team who's on standby to ask you questions and to book you for that appointment, okay? All right. And thank you for all the questions. Just to let you know, I am live streaming on 4 different platforms, on TikTok, Facebook, and Instagram, as well as YouTube. So a big shout out to all of my followers everywhere. And if you're not following me somewhere else, go ahead and look me up everywhere else. All right. So I have a question from Syed Ahmed, who's asking about the new policy for expedites of new fee categories. Will this affect people's filing labor certification? I can't answer that, but definitely follow me on YouTube because I just posted a video about this today. Now, these are expected guidelines. It's an intention. Nothing is in place yet, so nothing is being expedited just yet. And Jordan Chick, if you have a question, go ahead and ask it here. AZ Chandler is asking, can my wife ask for me if I have a misdemeanor? AZ Chandler, and anyone who is curious about filing for immigration benefits, but you have any sort of criminal history, whether it's a misdemeanor or a violation or felony, an analysis is always required in your case. And you have to get the documentation of what happened in your case, because even though it may be a misdemeanor, we still have to analyze it. And we also have to disclose it, because anytime you file for an immigration application, immigration is going to be performing several different background checks on you to look for anything that's related to encounters with law enforcement. So it's important to be upfront and disclose all these things, even if it was dismissed or expunged. Okay. Give me one sec. I'm just blocking someone who's mad that I work with immigrants. And I don't really care. Yes, I work with immigrants. I work with persons who are undocumented, and it's my privilege and honor to do so. My belief is that immigration laws are man-made and they're very arbitrary. And it's too bad that some people benefit while others can't. So I do what I can within the system to help those who need help. Is the green card process still backed up due to COVID from Gabby? Gabby, yes, it's still a little bit backed up. It's still a little bit slow, but they are trying to work as much as they can to help fix the backlog. Okay. All right. Hi, Moumita. My green card holder wife wishes to divorce soon. She wants to stop my work permit. How about my USCIS process? From Sadiq in Florida. Sadiq, if you are married to somebody who is a green card holder or a citizen and they want to stop your case, they want to cancel your work permit, they want to cancel your case, they want you to go back home so that you don't get anything, I want you to give me a call at 212-248-7907 so we can book you for an appointment to evaluate your case. Because the truth is that when somebody tries to control your immigration status, when they want to prevent you from having this benefit that could possibly cause you to get deported, get thrown in jail, all these things, to me, that is a sign of control and manipulation and abuse. And you may very well qualify to do a green card application on your own or continue the green card process on your own through the Vawa self-petition. And I would be very happy to evaluate your case to see if this is a good option for you. So hope to hear from you soon, Sadiq. All right. Hi, Maruf. Hello to all of my Instagram followers. Okay, let's see what we have over here. Hi, Gabby. How are you, my friend? All right. How long does advanced parole processing take for TPS from Pankaj? Pankaj, advanced parole for almost every case is taking about 10 months or more, but you can look up this question on your case, on the case processing timeline on USCIS. Okay, so Coco is asking en español, con mi employment authorization, ¿puedo sacar mi licencia de manejo? Coco, sí, sí tiene un employment authorization o su permiso de trabajo, es posible aplicar, how do you say, a pedir por su licencia de manejar, ¿sí? En todos los estados, en almost todos los estados, necesita el permiso y también necesita su número de social seguridad. Okay, so good luck to you, buena suerte. I hope you get your license to drive soon. Okay. I'm documentarily qualified, but no appointments for interview till date of last year. What can I do? From Peter Ajay. Anyone who is waiting for a consular interview overseas at a consulate, if you've been documentarily qualified for a long time, the best thing that you can do is wait. And if you have any emergency, you can always ask for an expedite with proof. Can I apply for a Vawa if I missed my I-485 interview 2 times because my wife was not agreeing and always fights with me? From Mani Bajwa. Yes, you can. So if you have started the green card process with your spouse, you missed your interview because your spouse is giving you trouble the morning of the interview or demanding things of you before you go in order to go with you to the interview, or you miss it for, due to the sabotage of your spouse, whatever the reason is, it doesn't matter if you've missed it twice. As long as you qualify for a VAWA, you qualify for a VAWA. Of course, we should explain what happened. If you may get your I-485 denied if you missed your interview, but still, we can still file for your I-485 again to put you back on that pathway towards a green card, okay? So, Manny, give us a call, 212-248-7907. Don't wait for the denial. If you have already started your green card process and your spouse no longer wants to help, wants to cancel your case, wants to withdraw their support, the time is now to take action and call us so that we can help you keep moving forward in the direction that you deserve, okay? All right, let's see what other questions I have. And hello to everyone who's joining. Which is the best way to remove conditional conditions? Divorce or VAWA? From Fashion Portrait. Fashion Portrait, and anyone else who has a 2-year residency card that you got through marriage, and now your marriage is either over or your husband or wife does not want to help you file for the 10-year green card, what is the best way? Should you do a waiver through divorce or a waiver through extreme cruelty and battery? Well, it really depends on your case. So for example, if you want to file for it through divorce, you must have the divorce certificate. Your marriage must officially be over and it must be legally terminated. Otherwise, your case will receive a request for request for evidence for that divorce certificate. So I do not recommend that anyone file for the divorce waiver unless the marriage is legally terminated. Now, the reason to file for the extreme cruelty and battery waiver is because you have gone through many bad things during your marriage. And if you have gone through, manipulation, control, threats of harm, threats to send you back to your country, physical abuse, sexual abuse, financial abuse, whatever you've gone through, I believe that it's always good to file for this waiver for 2 reasons. Number one, if you don't have a lot of evidence from your marriage because of the fact that your spouse doesn't want to put you on the accounts, they won't give you access to documentation, and you just generally have very little joint marriage evidence. And the reason for that is because of what you suffered by your spouse. That's a good way to explain why. Otherwise, if you file based upon divorce waiver and you only have just a little bit of evidence, then they're going to push back and they're going to say, please prove your good faith marriage. So that's one of my strategies. And number two, when you get approved for your I-751 through the extreme cruelty and battery waiver, you're you only have to wait 3 years total for the citizenship. So almost all of my clients are eligible to file for citizenship right away. Otherwise, if you file your I-751 based upon a divorce waiver and it gets approved based upon the divorce only, then you have to wait 5 years to file for citizenship, okay? So there's a huge benefit to that. All right. See what other questions I have. Peke Ocampo is asking, if you already filed for divorce, I have 20 days to respond. From Peck. So Peck or Bonbon, sorry, I'm not sure how to pronounce it. I don't do divorce, and divorce is the divorce laws are different state to state to state. So it's different in New York from what it is in Florida, from what it is in California. It's going to depend. So if somebody files divorce against you, normally you have to respond back within the time that it said. Otherwise, you may end up getting a default judgment against you. Cynthia's asking, what if I'm married for almost 6 years and he has disappeared? From Cynthia. Cynthia, if you're an immigrant and your spouse who's a US citizen has disappeared, I don't care how long it was. When a spouse abandons you, that's actually a form of emotional abuse. And I would be very, very happy to help go through your options and to see if you qualify for the Vawa self-petition for a green card. They call it the self-petition, the autopetición, because you have control. Es su propio caso, see? And it's your own case. You get to decide what's going to happen to you. So give us a call if you need some help. Ravi is saying, thank you so much. Okay. Let's see. Samantha Lee is asking, I'm a U.S. citizen and filed my dad's I-130 last July. My dad resides in Mexico. Can I expedite the application for work-related reasons? My hubby and I own a construction and can't find employees. Samantha Lee, it's a good question. So if you are filing an I-130 for anyone who's overseas or even in the U.S., really the only way to expedite it is if there is any sort of emergency. And what immigration considers to be an emergency usually has to do with some sort of urgent humanitarian need, medical emergency, or a risk of financial loss. So from the way that you're saying it, Samantha, it sounds like your dad's application is very separate from your construction company. I don't see how the two correlate, but maybe your dad has some other reasons, such as a health-related reason or something like that that can be used to request an expedite, okay? So good luck with that, Samantha. All right. So I'm going to just answer this from Viber. So Viber, no, I don't do national interest waivers at all. But I must say that it's kind of difficult to do this live when people demand that I answer questions. Please be happy that I'm here to answer questions live. And if I don't answer your question, I'm really sorry. It may be because either I don't have time or it's dealing with something. You're asking me about something that I don't deal with. Okay. Thank you so much, Viber. I filed for Vawa alone last year. It's been 11 months since filed. And what's next? From Ashlyn. Ashlyn, the next thing to do is just to keep waiting. The Vawa cases take a very long time. They usually take anywhere from 18 to 36 months sometimes to be approved. So you're going to have a long waiting period. I know it's a very, very long time to wait with no information, no communication from immigration. It's like you are stuck in a black hole. Right? Am I right? Anytime you file something with immigration, it's almost like you're stuck in a black hole with like no light out. You have no idea what's going on. You cannot find any answers or any information. And it's really, really difficult. But what I can say is this, if you're worried about how long your case is going to take, immigration does actually have a link on their webpage that's called the case processing timelines, and you can try to estimate how long your case is going to take. For a Vawa application, it is definitely true. You're probably going to wait a couple of years for an answer. And no news is sometimes good news, because sometimes when they do reach out to you, it's either to request more evidence or it's to give you a decision. So hang in there, hang tight, and hopefully you'll get some news soon. And Jeffrey Delarmonte, same thing for your question. I don't really deal with I-140, so I have no information for you. And if your friend is overstayed, probably it may be a factor, yes. All right. Let's see. I'm a U.S. citizen. I want to submit an application for an I-130 for my 3-year-old child. How can I expedite the application to get an approval? From Sam King. Sam King, if your child is a 3-year-old and they're out of the country, then probably what I would say is that maybe you can request an expedite due to a humanitarian reason, so you could be reunited with your minor child, right? So try that. All right. Vanessa Jacqueline is asking, how much is one consultation? So Vanessa on Instagram, thank you so much for the question. A consultation is $150 for a phone or video appointment for me to go over your case, okay? And I hope to hear from you soon. Someone's asking, I live in California. Can you still help me? From Benny Boy. Benny Boy, yes, I have many, many clients in California. In fact, I have clients all over the United States. I'm very fortunate to be able to do the work that I do and to be able to reach and help so many immigrants all over. It's truly, I'm very grateful for this chance. And we work remotely, we work virtually, so we have it all covered to make it as easy for you as possible. In fact, it's probably going to be easier for you than working with an in-town attorney that requires you to go to their office for every single thing, right? Can a green card spouse sponsor a spouse that overstayed in the U.S. from Andrew? Andrew, no. If you're a green card holder and your spouse has overstayed and you want to sponsor them, then you can sponsor them, but they're probably going to need a waiver for their overstay. So they won't be eligible to do the process here. They'll have to go over to their country for an interview, or you can wait until you become a citizen in order to get a case processed for them. Because when you're a U.S. citizen and your spouse has overstayed their visa, it doesn't matter how long they overstayed their visa. Usually a benefit that they will get is that the government will kind of overlook and forgive that overstay. Very interesting question from Jeannie. Jeannie is asking, how long does it take for a dreamer when you apply for Vawa? Let's see. So Jeannie, as long as you're eligible for Vawa because you're married to a citizen or to a green card holder, it's going to take you the same amount of time as everybody else. Normally, I would say the average time is about 2.5 years for the total case. What is the earliest EAD under I-360 when the I-485 is filed together? Elvis, I'm not sure I understand this question, but I would say the EADs have a really broad time range when you file underneath the VAWA. Sometimes we get it approved in 2 months. Sometimes we're waiting like 10 months, so it really depends. I'm an international student and I'm turning in my college. What should I do now? Rana, you need a consultation in your case to find out what your next options are. I'm already applying for my spouse's immigration, but he's not in America. I'm waiting for the approval from USCIS, but I'm filing for my taxes and don't have a Social Security. Alicia, you need to speak with an accountant to find out the best steps, okay? All right. If someone is married to a U.S. citizen and has an asylum pending, what does he have to choose? Good question from Jyoti Daliwa. If you have asylum processing and you're married to a U.S. citizen, what do you have to choose between? And I would say it depends on your case. If you have a really strong asylum case, I would not give that up until you're sure that you're going to get a green card through your spouse. But you have to also look at certain things, right? Like, how did you come into the country? Do you have a legal entry or an illegal entry? Because if you don't have a legal entry and you're married to a U.S. citizen, your process is going to be a little bit more difficult. So it really depends on your case. You may have to choose between one or the other, but definitely do a consultation with a qualified immigration attorney to find out the best options. And I would say give us a call at 212-248-7907. No DACA news right now. Let's see. If me and my fiance get married but have a baby, would he still have to go back to Honduras and wait from Acacia? Acacia. So if you and your fiance get married and you have a baby, whether your husband would have to go back to Honduras or not would depend on his manner of entry to the U.S. and what cases he qualifies for. Now, whenever somebody comes to me and I know that they don't have a legal entry, I look for as many ways as possible to see if they qualify for the various cases that do not require leaving the United States for the interview. But sometimes it's not always possible. And if the only thing possible for your husband is to do the Perdon, which would require him to do that, then we would do that. Now, I know that some of you are very scared at doing the Perdon, and I can say that I've had success with both of them. Of course, it's a little bit riskier, but I would say, Acacia, give us a call for an appointment, 212-248-7907, so we can go through your best options, okay? All right. Can you apply for a green card after your 6 months? From Fantastic. I'm not too sure I understand that. I'm a U.S. citizen and I just applied for my husband who once had DACA. How long will that take? From MJS for life. MJS, it depends on your husband's situation and whether he has a legal entry or not a legal entry, because that will dictate what he qualifies for, okay? But definitely give us a call if you need some assistance with your case. I'm a U.S. citizen and I want to petition my parents. How do I start from Morales? Morales. Definitely, the way to start is to file the I-130, and I would be happy to help you. If your parents are not in the U.S. and you're a U.S. citizen, yes, you can bring them to the U.S. The process can be a little bit long, especially if they're in Mexico. It's going to take a long time for an interview, but you got to start now, because think of it this way. It's kind of like standing in line. You've got to get yourself in that line, okay? So definitely give us a call if you need some assistance with your case, 212-248-7907. Is it possible for a perdon to be approved 5 years before the 10 years bar from A. Flores? A. Flores, yes, it may be possible depending on whether the person has the permanent bar or the regular 10-year bar, and whether they have qualifying relatives. We can, if it's just the regular 10-year bar and there's a U.S. citizen spouse or a green card holding spouse or parent involved, then we can definitely apply for a permission basically to end that bar a little bit quicker, okay? All right, everyone, that is all the time I have for today. I hope everyone has a blessed night. Take care. Thank you for watching. If you need an appointment with me, listen, what I would say is there's a lot of people come to me saying, hey, Moumita, I have been watching you for 7-8 months and I'm here now. And I say, first of all, thank you to everyone who keeps watching me. I hope to be able to keep spreading my message of hope and opportunity for all of you. Please share my videos with anyone that you think might benefit from them, from the information, and or who needs my help. And if you have been watching, don't wait any longer to take the steps that will improve your life. Give us a call, 212-248-7907. Yes, you may wait a little bit of time for an appointment, but you know what? Good things come, right? So have a great day. Bye.